Good afternoon. I'd like to thank, first of all, the conference organizers for including me, and the conference staff for feeding and watering all of us. Thank you very much. It's been a very full morning, and I think it will be a full afternoon. The Ethnographic Museum in the 21st century is a dense site for exploring issues of redress and repair for injustices, both historical and continuing, that are posed by colonial pasts. There are moral questions about just and unjust acquisition, just and unjust ownership and control, and the just or unjust distribution of powers to present and represent the objects themselves or the communities that are invested in their representation. And there's a bewildering array of communities to consider, varied publics and audiences of the museum, its source communities, and the communities, to speak loosely, culturally associated with its objects, distant, local, and diasporic. To speak about the moral issues in play in the 21st century existence and operation of the Ethnographic Museum, I'll begin with the recently consolidated international framework for reparations, but I will extend the discussion to two core facets of justice that underlie obligations of repair: accountability and reciprocity. I believe that accountability has dominated in the formation of principles of just repair in European-dominated contexts, including those now established for reparations, while reciprocity remains recessed. Yet practices of reciprocity can directly confront not only the material exploitation and plunder, but also some of the moral insult of denigrating the agency and competence of previously colonized people that is at the center of colonial histories and that can continue to influence practice today. Thinking about reparation for grave injustices of all types has been given significant structure by the emergence of widely recognized international guidelines. The United Nations 2006 Basic Principles and Guidelines, it's a much longer title, I'm just going to call them the Basic Principles and Guidelines on Remedies and Reparation, details a varied repertory of reparations practices alongside general requirements of access to justice and access to relevant information about abuses and reparations. I'm going to focus on the reparations practices. This cluster of practices was distilled from several decades of actual reparations thinking and action around the world in the aftermath of widespread human rights abuses. Contributing developments included actual programs of reparations following political violence, for which German reparations for the Holocaust were a sort of originating and signal event. Recommendations for appropriate reparations by truth commissions, decisions of international courts, especially perhaps the Inter-American Court of Human Rights, awarding reparations to victims of human rights abuses, reparations proposals and demands by NGOs and victim advocacy groups, and academic scholarship in several fields. Now, I stress these many tributaries that flowed into the now formalized standards for reparations because they give reasons to view the guidelines that have emerged as the fruit of many actual struggles for the repair of injustices and of different modes of thought, political, legal, academic, and perhaps to a lesser extent, culturally varied, that have constituted these standards. As such, the standards might be seen as the result of a kind of global experiment, importantly, an experiment that needs to be continuously rethought and updated, but an experiment in uncovering the different meanings of justice in repair. While reparative duties in the Basic Principles and Guidelines are addressed to state actors, and some can only be enacted by states, the consolidation of understandings about justice in repair I think, can serve as a model for other institutions and actors. And the variety of modes of reparations that are recognized and endorsed is striking. In brief, the basic principles suggest 5 categories of reparations measures, each of which comprehends a variety of applications. Restitution encompasses return of goods and property, but also extends to restoring liberty, identity, citizenship, and residence, among others. Compensation pays for damages of physical, mental, and moral harm, as well as varied material losses. Rehabilitation requires access to medical, psychological, and legal services to address the consequences of harms. Satisfaction comprises a wide variety of acts and gestures that affirm the reality of the offense, such as public disclosure of truth, assistance in finding human remains, sanctions against responsible persons, and also affirm the dignity of victims, such as apologies and commemorations. Finally, the 5th category, guarantees of non-repetition, comprises preventive measures to reform laws, institutions, and professions. These guidelines were formulated primarily to address so-called gross violations of human rights and also violations of humanitarian law, particularly crimes against the bodily integrity of persons and groups. Yet they are ripe with potential applications to other kinds of wrongs. And they can address participation or complicity in acts destructive to the cultural rights of communities and the human rights of free expression, religion, and cultural participation of the members of these communities, including removal or possession of objects important to cultural heritage under conditions of domination and exploitation. Each of these 5 categories of reparations can apply, and I'm not going to go through this step by step, and I leave it to those better informed to conduct this, but each of these can apply to the situation of the museum's relationship to its source and other communities of concern. In one example, rehabilitation might seem to lack obvious application in the case of people grossly injured physically. Rehabilitation can mean medical, and social services. But considered from the point of view of cultural injustice, rehabilitation suggests a wide array of forms of assistance to cultures and societies: legal, economic, political, educational, vocational, that have been affected by the collecting and removal practices that have helped museums to build the collections they have. One form of cultural injustice occurs when one group deliberately, arbitrarily, or negligently destroys or impairs possession or knowledge of the historical patrimony and cultural traditions of another group, or undermines the capacity of that group to sustain its cultural legacy and its associated knowledge and practice. And I drew on it Bargava's definition of cultural injustice. Rehabilitation, for instance, can entail active efforts to assist wrongly affected groups in rebuilding capacity and regaining a robust sense of control and enjoyment of its cultural inheritance, as well as its ability to determine the legacy of its culture for its future and other future generations. In another example, the importance of satisfaction, that other category, in the form of truth-telling and truthful information, has immense implications, not only for the museum's presentation and explanation of its possession and display of objects, but also for public examination of the museum's historical and contemporary self-conception and self-presentation. It suggests that the truths to be told include the ones that are important to those who challenge the justification of what the museum has been and has done, as well as what it is and does today. In this brief comment, though, I want to focus on the apparent dominance of repatriation claims in discussions of postcolonial reparative measures, something that's been mentioned many times here yesterday and today. Restitution seems to have the most obvious application to the situation of the museum, or especially museums of certain kinds. In numerous cases, ownership or control of objects can be challenged morally and increasingly legally on the grounds of improper or illegal removal or transfer of ownership, or based on the human right of communities to cultural property that is integral to their heritage and identity. In the context of colonial histories that essentially involve the extraction and appropriation of resources of many kinds, from the colonized to colonizers under conditions of conquest or political or territorial domination, massive transfers of art, artifacts, and structures are necessarily subject to moral appraisal. There are good reasons that repatriation has taken center stage. It's a straightforward instance of one intuitively strong pre-theoretical principle of justice. That is to say, it isn't just something that philosophers or lawyers get themselves into thinking about. This, what I call pre-theoretical principle, is a wrongdoer is obligated to rectify or make amends for wrongdoing. And restitution is the most literal fulfillment of this principle. Something wrongly taken must be given back. In many cases of wrongdoing, it is impossible to rectify by literal restitution. A victim of torture cannot be untortured. A disappeared and murdered spouse cannot be returned. In the realm of property, including tangible cultural property, return, however, is morally the simplest fulfillment of an easily recognized obligation. Now, I'm not saying that making the case for an object's improper acquisition or retention is simple. That may be very complicated. Nor is it to say that it's always possible or unproblematic to simply give it back, effect a literal return. And both of these things are true in, for example, disputes about indigenous land. Clearly, in a huge number of cases, flatly wrongfully taken. It is rather to say that once the case is made for wrongful possession, the moral remedy, legal and technical issues aside, of restitution seems clear as the first best remedy. So if it cannot be carried out directly, then the question of alternative or next best remedies arise. For example, compensation, loan, or special access in lieu of restitution. At the same time, the repatriation of culturally significant objects is layered thickly with other reparative meanings. It's not just giving the thing back or getting the thing back. The act of return acknowledges morally questionable, if not wrongful, possession. The successful demand for return signifies the attainment of power to demand the return of something, of which in many cases a group or society was, perhaps in complicated ways, powerless to prevent the loss. In the postcolonial context, wresting accountability from former colonizing societies and resuming control over cultural property of significance is a literal and/or symbolic reversal of historical terms of domination and submission that defined the colonial relation. If, along with political domination and economic exploitation, cultural injustice includes stripping and inferiorization of the self-defined culture of colonized peoples, the receiving communities regaining control of both items of material culture and the ability to define their meanings for culture and identity can be a potent source of cultural self-determination, vitality, and pride. In the case of human remains, repatriation or other dignified treatment is urgent as an expression of the full and unique individual humanity of the deceased. So I'm saying there are lots of reasons why the centrality of reparation as a requirement of justice is justified. Restitution is a transparent and literal exercise of accountability. Now, accountability means being liable to answer to others in the matter of one's conduct and to being exposed to the consequences of the judgment they make on one's conduct and how one answers for it, which they might, for example, find one responsible in ways that result in additional demands, like demands for repair. The requirement of restitution is a paradigm of this. If one is found responsible for wrongly acquiring what belongs to someone else, one can be obliged to return that particular object. Most measures in the international norms for reparations I mentioned earlier are accountability measures in either more literal or more symbolic forms: compensation, rehabilitation, the various forms of satisfaction, maybe a little less clearly, guarantees of non-repetition, are all requirements for an accounting and a response in a way that, in some sense, balances out specific wrongs in the past or their specific history of consequences. Accountability is an aspect of justice because a failure to honor our moral accountability to others and its implications for what we owe to them implies a refusal to recognize those others as having a moral claim on us, as being our moral equals. If others are our moral equals, we are obliged to account to them for how we treat them. If we are not obliged to account to them, then they are beneath our consideration. And of course, unless we accept mutual terms of accountability, no additional reparative obligations can even be raised. Yet, the dominance of repatriation issues can obscure a larger terrain of just repair with comparable significance. Ruth Phillips and Elizabeth Johnson, discussing Canadian museums and First Nations peoples, suggest that the relationship involved in repatriation is itself of deep value. They say, quote, "Repatriation negotiation should be understood not only as a struggle over ownership and a process for the return of cultural property, but also as a mechanism for building new kinds of relationships between museums and First Nations based on the articulation of common interests in these materials," end quote. Now, this observation highlights another aspect of just repair that embodies relationships of moral equality, namely reciprocity. In the postcolonial context, substantively reciprocal relationships in the care, understanding, and valuing of objects of cultural significance or patrimony, group identity, is an expression of reciprocity that goes beyond accountability. Substantively reciprocal relationships are ones in which the parties to the relationship recognize each other's relevant contributions in a given domain, and each recognizes the other's claim to consideration comparable, even if not identical, to the claim they themselves make on the other. So it's a as goes for me, goes for you principle. Leah Upi defines the wrong of colonialism as, quote, "the creation and upholding of a political association that denies its members equal and reciprocal terms of cooperation," end quote. Now, that may not be all there is to it, but that's certainly a wrong of colonialism. To instate and nurture reciprocal terms of engagement, authority, stewardship, and control with respect to communities' specific cultural relationship to collected items is a direct repudiation of the persistent patterns of disregard, paternalism, and contempt that afflict colonial political and human relations. The implications of reciprocal relationships are many. Phillips and Johnson, I already mentioned, in the Canadian context, Mentioned loan of materials for use in ceremonies in First Nations communities, creation of replicas for use by either the museum or the source community, development of shared management of cultural property, consultation and permission at all stages of representation and documentation, and using First Nations' own preferred names in exhibit texts and materials. Patty Gerstenblith, discussing the American statute, NAGPRA, the Native American Graves Protection and Repatriation Act, stresses giving credence to oral history and traditional evidence alongside scientific evidence, support for the creation of autonomous indigenous museums, indigenous staffing of non-native museums, which I think is actually rather important, and training of Native American scientists. An interesting paper about an apparently somewhat disastrous exhibit in Canada that was supposed to explore Canadian colonialism, some of you probably know this, in an article on this, Sonali Thekar explores the importance of engagement with local and diasporic communities that have a stake in particular materials and their representations. So you know better than I, and I've just drawn on some people with this relevant experience about what are some of the dimensions in which reciprocal relations could be attempted or established. Now, some of these measures might also be seen as fulfilling commitments to diversity in multicultural societies. But where colonial dispossession is the context, these measures, I think, should be clearly framed as repair for past injustice with specific reference to distinct colonial histories and the particular injuries that they embody. Building ongoing relationships that are at once accountable for specific histories in the past and reciprocally responsive in determining a future course is a multi-level project of repair. All reparations redress past injustice and will be tested by their contribution to a future that is not haunted by that injustice. But their medium of repair is the present, where relationships free of previous injustice are imagined, negotiated, and put in play. Thank you.